I'm really pleased to be joined now by distinguished immigration lawyer Ivon Sampson. Ivon, thank you so much for coming in. You think that the Rule 39 orders are a suitable and balanced approach?
They are. In fact, you were talking about them short-circuiting the judicial process here. They don't. They're interim measures. And what that means is they're not final orders, they're interim orders. And the difference is this: they allow the domestic courts to consider the merits of a case before somebody is affected by the measures. In the context of Rwanda, people being expelled to another country.
But our courts had already agreed with the government that if they ruled that the deportations were unlawful, that they would be taken back into this country. So it was already being settled in the domestic UK courts and didn't need the ECHR to intervene.
Well, that would have been great if they were sent to a wonderful country where they're going to be protected and cared for. Paul Kagame is the president of Rwanda, and he's involved in extrajudicial killings, arbitrary arrest, unlawful detention without trial.
Our courts had accepted that with the commitment from the government that they would be returned if the court found against the government, with that commitment,
yes,
that the flights could go ahead. Why should that be overruled secretively by an unnamed judge in a foreign country?
Because Rule 39 is the last chance that a person has to stop unlawful interference by a state. It protects an individual's rights. And if you were a judge in Strasbourg and I came to you and said, look, I need Rule 39, and here's evidence that this person, if they get sent back to the country, will face potential death, breach of Article 2, and torture and ill-treatment, breach of Article 3. If I showed you that evidence and you accepted it, would you have granted the order?
But it was overturning our courts, which had said that the government's position, on the basis that if the legislation hadn't been followed properly, the people would be brought back. Our courts were satisfied. Why should our High Court be overruled by one judge, not even sitting in the court, possibly dragged out of bed to sign the order? Why should that be a better legal system than doing it domestically?
Because it's not concluded through our courts. That the December ruling was then given right to appeal. The Court of Appeals gave them right to appeal. So it hasn't been decided.
No, but that's the point, that the ECHR is not meant to be involved until it's been decided by our courts, and our courts had accepted a level of protection for the individuals involved. Why wasn't that good enough? Why was that overruled without a proper hearing in Strasbourg?
Because that's what Rule 39 does. It prevents a signatory to the Convention from expelling an individual until the merits of the case has been decided. And that's fair. We've got to uphold the rule of law, the principles of fairness. We can't just send people out of the country.
But the rule of law is really important because courts do not have powers that they have not been given. When did Parliament legislate to give the ECHR this power?
Well, Parliament is supreme. Parliament can enact anything it likes. You're a parliamentarian. This new amendment to the bill, now it's interesting, what it says is that the Home Secretary has the ability to do it. She will not do it. Well, she will never overrule a Rule 39.
To go back to Rule 39, we never gave the ECHR that power. Our courts have the power of injunction, but the ECHR has taken this power for itself. It's not what we signed up to, because we've got protections in our own courts, and that's the point I'm trying to get across.
Jacob, we don't. Look, judicial review is a normal process to stop a removal. Well, judicial review is no longer suspensive. It used to be until the government curbed judicial review, and especially if they charter a flight. If they charter a flight, judiciary proceedings are non-suspensive. You can still remove. So that's why they had no choice but to go to the...
No, because the High Court had already agreed with the government in this specific incident that if people were found to have been removed unlawfully, they would be returned. And that's why they didn't use any injunctive power, even ask the government to delay the flights, because the government and our courts had come to a compromise that allowed the case to proceed at the normal pace. And then there's suddenly this interference from Strasbourg.
What is the urgency of removing people until their case has been decided?
Oh, the urgency is to make the law seem to be effective, and to act as the deterrent effect to deter the small boats. That's the importance of it.
Politics.
No,
not fairness.
No,
not principles of fairness.
Fairness in implementing the law that Parliament has passed. Surely, if Parliament has passed a law, you shouldn't override it until there is evidence that it's wrong.
Well, interesting enough, when the judge gave the Rule 39 order, Parliament could have ignored it. It didn't. Why?
Oh, well, that's a very good question, and that's why Parliament is now legislating to give the power to overturn these rulings. There wasn't at that point a mechanism for Parliament overruling it.
I agree with you. I don't think that the current Home Secretary will overrule any further Rule 39 orders. Do you know how many Rule 39s are ordered each year?
I mean, it's a relatively small number.
Yeah, it's a tiny number. So it's rarely ever used. It's only used in extreme situations, like Rwanda.
Not all signatories actually accept Rule 39 orders anyway. Yes. We do, but a lot of other member states don't. So we are making our approach, with one of the best legal systems in the world, less able to operate than countries with less good legal systems. Can that possibly be sensible for us?
It is sensible because it protects individual rights. Look, the Strasbourg will not placate the UK Parliament in agreeing to change Rule 39 in a way to allow the UK not to ignore it. They will not do that. The only way Parliament can do that is to have an amendment, have that power, but the Home Secretary will never use it.
The right of Parliament to legislate is absolute. I'm very much a Dyson in that context, and parliamentary sovereignty can legislate for anything. I mean, ultimately, we'll probably have to legislate to pull us out of the European Convention in the jurisdiction of the ECHR.
That is the plan for the government, I believe.
Because the ECHR is overreaching itself, and Rule 39 is symbolic of that, because we never gave them that power. Didn't it work better when the ECHR gave its judgments and they were non-binding, and then we could decide whether they're right or not? And we followed most of them on that basis, but it didn't override the democratic rights of the government, which has a majority in Parliament.
If I'm being abused by the government, if my rights are being infringed by the government, I wouldn't want the courts in this country to consider it, and that's how I personally feel about it.
You wouldn't want our courts to consider it?
No, I wouldn't. I would like to have the last court of resort should be outside the country for matters of life and death. I don't believe that's right. I think we need a court outside this country, like the ECHR, as the last court that I can appeal to.
OK, but this is where we fundamentally disagree, because I think our best court, our best protector of rights, is the High Court of Parliament and that democracy.
No, because Parliament can legislate to limit the court's powers.
And that has developed our rights. It is this democratic power that has arisen. I mean, you can go right the way back to Magna Carta.
But Parliament
But you must come back on to discuss that on another occasion, because I've run out of time. But thanks so much, Ivan. Don't forget to let me know what you think. mailmog@gbnews.uk.